Over the years, I've had many clients say to me, Mike, the police didn't read me my rights. Will my charges be dropped? That's a pretty loaded question, first of all. The answer is maybe yes and maybe not. Let's break it down now. What do the police have to do when they arrest you? Well, first of all, under our charter, they have to give you your reasons for arrest, first and foremost. They start with that, okay? They arrest you and give you reasons for arrest. Secondly, they're going to read you a right to a lawyer, that is right to counsel under Section 10B of the Charter. You have the right to retain and instruct counsel without delay. And that's a phone call. They have to provide you a phone call before they start interrogating you or answering questions. So that's under Section 10B. And third, they're going to give you what's called a police caution, words to the effect that anything you say can and will be used against you in a court of law. So those are the fundamental things that the police need to do, aside from other procedures when they arrest you. So what if they don't do those? So let's break it down. So what if they don't properly give you the rights to counsel? And rights to counsel is a very complicated area. The police not only sometimes forget to ask, but they make mistakes. Well, what happens then, if you have a good lawyer and you bring a right to counsel application, and the lawyer can show that there's one of a million different mistakes that the police literally, I should maybe exaggerating a little bit, there's thousands of different issues on rights to counsel. The case law is very complicated. So if you can show there's a breakdown in that, they didn't read the rights, that's the most simple one, but there's branches of those that devolve from that. Then you make an application to exclude evidence under Section 24(2) of the Charter that has brought the administration of justice into disrepute. But the thing is, the only thing you can exclude if they breach the right to counsel is evidence occurring after the breach. So take a look at that now. That might be a confession. So you're arrested, you go back to this police station, you confess to a crime. Well, if they didn't give the rights to counsel, that confession might be excluded under Section 24(2) and not heard at trial. But the police may have other independent evidence that you, for example, 3 witnesses to a murder as an extreme example, they're going to continue with the case. So that charge would not be dropped. Let me give you another example though. Let's take impaired driving. So an over 80 case, you blew over the legal limit. Let's say there's a breach of the rights to counsel. Okay, in that situation, one of the many branches of the breach, there's a ton of them, I won't go through the many of them, but let's just do an obvious one that you could show that they actually didn't even read it or provide it. That's the most basic one. That's more of a rarity, being that usually it's the branches that win the case, the more technical issues. Now, in that situation, the breath readings could get thrown out. So those 2 breath readings that they do in the intoxilizer back at the police station after they arrest you, that could potentially get thrown out of Section 24(2). Well, if there's no bad driving and all the evidence they have are the breath readings, well, you win that case. So there's an example where the charges would get dropped. That is probably won at trial, or maybe the Crown might offer a deal if ahead of the case for careless or even outright dropping it. So it really depends, rights to counsel. It's a loaded question. I have to get the disclosure first to see if there's other independent evidence that can prove their case aside from the evidence that flows from the breach. In the States, they call this the fruit of the poisonous tree. So if the police screw up in Canada, they don't give you the rights to counsel, the evidence that they find following that may get excluded. Not the evidence before though, like witness statements, evidence of a crime. So that's a fundamental point. Impaired driving, though, is a different situation. We often do get it dropped if there's a right to counsel breach. Now, with respect to cautions is a very tricky area where they give you a police caution. And what happens here, again, the same idea, one of the factors in deciding whether a statement gets in Canada, aside from whether there's right to counsel, and the main factor is voluntariness. Was it a voluntary statement, or was it induced by threats, promises, or inducements, or an oppressed state of mind? Now, one of the factors to determine whether a statement's voluntary, and by the way, the Crown has to prove that a statement that the police took from you back at the police station after arrest was voluntary beyond a reasonable doubt. One of the factors the court will look at is whether you're properly cautioned. Look, you don't have to say anything, it can be used against you in a court. That's one of the factors. So just because you weren't cautioned, it won't necessarily be thrown out, but it's an important factor in that determination. And other factors are what happens in the room. Did they breach your right to silence? Were there oppressive circumstances? Did they make any threats? But a caution's a big thing. So if a proper caution is not given and your lawyer is successful in getting a confession thrown out, the charges may not be dropped there either, because again, it's the fruits of the poisonous tree flowing after the caution, which is the confession. There may be all sorts of other independent evidence to prove the case aside from that. So that's the answer I give clients. It really depends. We need to get the disclosure, determine how dependent is their case on the evidence which occurred after the breach of rights to counsel or after the caution. If their whole case depends on the evidence which was found after, for example, you gave a confession which you said led to the body, and that's their only case, and you can get that all thrown out, well, they may not have a case, but they may have a case before that. So there you have it, a slightly complicated answer to trying to break down, I'm trying to give a simple answer to a complicated issue under Canadian criminal law. Thank you for joining me today. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.